And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
A seismic shift just hit the American legal system. And if you're a gun owner, you're now standing on a completely different landscape than you were just 30 days ago. We've seen a federal appeals court basically dismantle the old machinery of gun control, and as of this month, 10 massive transformations have gone live. Now, I need you to stick with me through this entire breakdown, because change number 10 on this list is a complete 180-degree turn. We are talking about something that used to carry a mandatory 10-year federal prison sentence, but now it's officially recognized as your fundamental constitutional right. Welcome back to Law Advisor. We are on a mission to hit our first 1,000 subscribers, and we're doing that by bringing you the raw truth about the legal shifts that the mainstream media is too afraid to touch. So, do me a favor. Hit that subscribe button right now, turn on your notifications, and let's get into why your rights just got a serious, high-level upgrade. The first big change, and arguably the most important, is what we're calling the constitutional shield. For decades, the judicial system treated the Second Amendment like a junior right, a second-class citizen in the Bill of Rights. But those days are over. Federal courts have now officially elevated your gun rights to the level of strict scrutiny. To the average person, that sounds like legal jargon, but in the courtroom, it's a nuclear bomb. It means the Second Amendment now has the same maximum protection as your right to free speech or your right to practice your religion. This is a massive win because it completely flips the burden of proof. In the old days, if a state passed a restrictive law, you had to go to court and prove why that law was unconstitutional. Now, the burden is 100% on the government. They have to prove why they have the power to stop you. Under strict scrutiny, the government must pass a 3-part test that is notoriously difficult to survive. They have to show an urgent, compelling state interest, not just a vague public safety goal. Then, they have to prove that their specific restriction actually solves that problem. And finally, they must prove it is the least invasive way to achieve that goal. If there is a way to achieve safety without infringing on your right, the court will now strike the law down. Constitutional scholars who are tracking this shift believe that over 60% of current gun regulations, from waiting periods to feature bans, will collapse under this new pressure. Next, we have to talk about a major win for justice: personal accountability for law enforcement. For far too long, there has been a massive wall between citizens and the police called qualified immunity. This legal doctrine basically allowed officers to violate your constitutional rights, seize your property, or arrest you for legal activities. And as long as they could claim they didn't know they were breaking the law, they were protected from lawsuits. Well, that shield has just been stripped away for Second Amendment violations. Officers at every level, from local patrol units to federal ATF agents, can now be held personally liable in a court of law. This means that if an officer illegally seizes your firearm or arrests you for a lawful carry, you don't just sue the city, you can sue the officer's personal bank account. We are already seeing the fallout. In major cases across Texas and Florida, officers are being hit with million-dollar judgments that they have to pay out of their own pockets. In some instances, veteran officers have lost their entire retirement pensions because they chose to ignore the law. The message to the street is loud and clear. If you violate a citizen's rights, the department won't be writing the check. You will. This creates a massive incentive for officers to actually learn the law instead of just following orders from anti-gun politicians. The third transformation is the total dismantling of the red flag machine. For years, red flag laws have been the ultimate weapon for government overreach. They allowed the government to take your property without a crime ever being committed. The practice where an angry neighbor, a disgruntled coworker, or a bitter ex-spouse could have your front door kicked in and every firearm you own seized based on a single, unverified phone call has been ruled unconstitutional. The court has finally recognized that the 14th Amendment's due process clause actually means something. The new standard is ironclad. No arrest, no criminal charges, no seizure. You are now entitled to a full day in court with a lawyer and the right to face your accuser under oath before a single piece of your property is touched. This effectively ends the era of seize first, ask questions later. If you are one of the thousands of Americans who had guns taken through these programs in the last 5 years, your path to getting them back has just opened up. The government is now on the hook to return that property immediately unless they can prove a specific violent crime was committed. And for those of you worried about your privacy, the courts have issued a massive database deletion order. We've known for a while that the ATF has been caught secretly building a digital registry with over 1 billion records, tracking who bought what, when they bought it, and where they live. Despite federal law explicitly forbidding a national registry, they did it anyway. But the court has just called their bluff. They have given the federal government 90 days to wipe those servers clean. We're not just talking about hitting delete. We're talking about a permanent forensic level destruction of the data. verified by independent auditors. This also puts an end to state-level data mining. States like New York, Maryland, and California can no longer feed your private purchase records into federal databases through information sharing agreements without a specific warrant. This is a huge victory for the right to be left alone. It restores the original intent of the law, that the government has no business knowing what is in the safe of a law-abiding citizen. This leads us directly into the digital surveillance shutdown. For the last decade, federal agencies have been tracking your digital footprint in ways that would make your skin crawl. They've been using geofence warrants to see who walked into a gun store based on cell phone tower pings. They've been monitoring credit card transactions to see who is buying bulk ammunition or firearm parts online. The court has finally stepped in and ruled that exercising a constitutional right is not suspicious behavior. The programs that automatically flag people for looking up FFL transfer procedures or state carry laws on Google have been terminated. If the government wants to look at your bank statement or your search history now, they need a specific warrant signed by a judge, and they must prove that you are connected to a specific violent crime. The simple act of being a gun owner is no longer a probable cause for the government to spy on you. Over 60,000 citizens who are being monitored are now eligible for legal settlements, and this ruling ensures that your digital life stays private. On the administrative side, we are seeing a total overhaul of the permit processing system. In many blue states, the government was using bureaucracy as a weapon. They would take 12 months or even 2 years just to process a simple concealed carry application. They were using the slow walk to deny people their rights. But the new federal standard has put a hard stop to that. Every state in the country is now under a mandatory 30-day deadline. If your application isn't approved or denied with a specific legal reason within 30 days, it is now considered automatically approved by operation of law. Furthermore, the court has recognized that high fees are just a poll tax on the Second Amendment. They have capped total application fees at $50. They can no longer use $400 processing fees to keep low-income citizens from protecting themselves. This change is already creating a massive wave of newly licensed carriers in states that used to make it nearly impossible for the average person to get a permit. We also have the restoration of ammunition access. For years, anti-gun legislatures tried to backdoor gun control by attacking the ammo. They knew they couldn't always ban the guns, so they made it impossible to buy the bullets. They required background checks for every box of .22 LR. They banned online sales, and they blocked home delivery. The court has finally stated the obvious. A firearm without ammunition is just a very expensive paperweight. Therefore, ammunition receives the exact same constitutional protection as the firearm itself. Every state-level ban on online ammunition sales and home delivery has been declared unconstitutional. You can now order ammunition from the comfort of your home in all 50 states and have it shipped directly to your door. The government is also prohibited from keeping purchase lists or tracking how much ammo you buy. This has already caused online sales to skyrocket by over 300% in states that previously blocked shipments, bringing prices down and availability up for everyone. For our local gun shops and small business owners, there's a new safe harbor for dealer licenses. Under the previous administration, the ATF implemented a zero-tolerance policy. They were shutting down mom-and-pop gun stores over tiny clerical errors, like a dealer writing Ave instead of Avenue, or customers' handwriting being slightly illegible. They weren't looking for criminals. They were looking for typos to justify closing shops. That policy is finished. The new ruling creates a legal safe harbor for dealers. Paperwork errors are no longer grounds for license revocation. Unless the ATF can prove a willful criminal intent to facilitate illegal sales, they cannot touch a dealer's license. This has already sparked a massive resurgence in the industry. Applications for new federal firearms licenses have jumped by nearly 100% in the last 8 weeks, as entrepreneurs are no longer terrified of having their lives destroyed by an ATF inspector with a bad attitude. The ninth major change is the ban on warrantless inspections. Federal agents have a long history of showing up at the homes of collectors or home-based dealers without warning. They would show up during dinner, demand to see your safe, and use intimidation to gain access to your private property. They would claim that because you have a license or a collection, you consented to these surprise visits. The court has reaffirmed the Fourth Amendment. Your home is your castle. Owning a firearm or holding a business license does not mean you sign away your right to be free from unreasonable searches. From now on, if an ATF agent wants to see your books or your guns, they need one of two things: a scheduled appointment that you have agreed to, or a warrant signed by a judge. Period. If they show up at your door without a warrant, you have every legal right to tell them to leave your property. This restores the dignity and privacy of every gun owner in this country. And finally, we reach change number 10, the federal shield for interstate travel. This is the one that has historically landed good, law-abiding people in prison for years. We've all heard the horror stories. Someone from a free state is driving to visit family. They take a wrong turn or stop for gas in a state like New Jersey or Maryland. They get pulled over for a minor traffic violation. And the next thing they know, they are facing a 10-year felony charge for a gun that is 100% legal in their home state. The court has now established a federal interstate shield that is far stronger than anything we've seen before. It provides total immunity. As long as your firearm is legal in the state where you start your trip and legal in the state where you end it, you are 100% protected for every single mile in between. The old rules said you had to be in continuous travel, but the new ruling clarifies that you are allowed to stop for gas, you are allowed to eat at restaurants, and you are even allowed to stay in a hotel overnight without losing your protection. If you are pulled over in a restrictive state, you simply state the phrase. I'm traveling under federal interstate protection. This effectively ends the felony trap that has been used to target gun owners for decades. These 10 changes aren't just minor adjustments. They are a complete rebuilding of the legal framework surrounding your rights. But here's the reality. These protections only work if you know they exist and you know how to use them. The government isn't going to tell you that your rights have been restored. They're going to keep trying to enforce the old, unconstitutional rules as long as they can get away with it. That is why we are here at Law Advisor. We are dedicated to digging through the court dockets and the legislative fine print to make sure you have the knowledge you need to stay safe and stay free. We are pushing hard to hit that 1,000 subscriber milestone because we want to build a community of informed, responsible citizens who can't be intimidated by legal gray areas. So, if you found this breakdown helpful, please do us a favor, hit that like button, share this video with your local range group, and most importantly, subscribe to the channel. We read every single comment, and I want to hear from you. Which of these 10 changes do you think is the biggest victory? Is it the end of red flag laws, or is it the new accountability for police? Let's start a conversation in the comments below. Your support is what makes this channel possible, and it's what keeps the truth alive in an era of misinformation. Stay safe, stay smart, and never forget, knowledge is the ultimate defense. I'll see you in the next one.